Imagine coming home after a long day at work. You reach for your keys, you put them in the lock, and they don't turn. The locks have been changed. You knock on the door, but your landlord refuses to let you inside. Can they legally do that? The answer is simple: no. In the United States, a landlord cannot lock you out without following the legal eviction process. It doesn't matter if you're behind on rent. It doesn't matter if your lease expired yesterday. Until a court orders your eviction, your landlord cannot simply change the locks. Doing so can expose them to serious civil liability, and in some states, even criminal charges. First, self-help evictions are illegal. Across the United States, landlords are generally prohibited from taking matters into their own hands. They cannot change your locks. They cannot remove your belongings. They cannot shut off your electricity or water, and they cannot force you out without a court order. These actions are commonly known as self-help evictions, and they are illegal in most jurisdictions. In several states, including places like New York and California, unlawfully locking out a lawful tenant isn't just a civil dispute. It can also be a criminal offense. Depending on state law, a landlord may face criminal penalties in addition to civil lawsuits. When you rent a home, you receive legal possession of that property. The law protects your right to peacefully occupy the premises. Lawyers call this the right to quiet enjoyment. Only a court can legally terminate that right. If a landlord interferes without legal authority, they may be responsible for paying substantial damages. There is only one lawful process. The landlord must first serve a written eviction notice. Depending on the state, this could be a 3-day, 5-day, or 14-day notice. The notice must comply with state law. If the tenant does not comply with the notice, the landlord must file an eviction lawsuit in court. They cannot simply change the locks. Only the court has the authority to decide whether an eviction is justified. A judge hears both sides. The landlord must prove that the lease was violated. The tenant has the right to present evidence and defend the case. Only if the judge rules in the landlord's favor does the court issue a judgment for possession. Even after winning the case, the landlord still cannot personally remove the tenant. The court issues a writ of possession to the local sheriff or another authorized law enforcement officer. Only law enforcement can legally carry out the eviction. If your landlord illegally changes the locks, stay calm, document everything, take photographs, record videos if possible. Call your local police department's non-emergency number to report the illegal lockout. Then contact a tenant rights attorney or legal aid organization as soon as possible. Depending on your state's laws, you may be entitled to recover financial damages. Knowing your rights can save you thousands of dollars and prevent unlawful evictions. If you'd like us to explain the landlord-tenant laws in your state, let us know in the comments. Subscribe for straightforward explanations of U.S. civil law, consumer rights, and legal issues that affect everyday people. And I'll see you in the next video.